Now, Doc, this issue about the criminal prosecution of Honorable Quayson and comments that have been made by the Attorney General. Dr. Okoboy says that the Attorney General has not said anything untoward. And that what the Attorney General said is expected of him as a prosecutor. Doc, I can understand your handicap when it comes to these issues. Because like you said, you are not a lawyer. But I can tell you as a lawyer that that comment the Attorney General made in court is the most irresponsible comment any Attorney General and Minister of Justice has made in the history of this country. Look, the fact that somebody is being prosecuted for a criminal offense, be it for perjury or forgery or any criminal offense, let me put it that way, is that a disqualification factor relative to his or her eligibility to contest as a member of parliament? The answer is no. The Attorney General is not just an Attorney General, he's also a Minister of Justice. He is also the leader of the bar. And therefore his words, his utterances, his conduct must show that he is interested in justice, not in politics. It doesn't matter that he is a chief legal advisor of the president who is a politician. He is also a Minister of Justice and the leader of the bar. And he knows, or should know, that the fact that he is prosecuting Honorable Gyakye Quayson doesn't disqualify him from contesting as a member of parliament. In fact, per the constitution that the Attorney General has sworn to uphold, Honorable Gyakye Quayson is only a criminally accused person. And therefore, he ought to be presumed innocent until proven guilty. At least you were taught that. During your first year of pursuing LLB, you were taught that every criminally accused person must be presumed innocent or is presumed innocent until proven guilty or until he pleads guilty before a court of competent jurisdiction. And so on what basis did Godfrey Dami say that Honorable Gyakye Quayson, now here I'm quoting him, is irresponsible? Look at the words he used, irresponsible, for putting himself up for election when he knows that he's standing criminal trial which can land him in jail.
So Sammy, let me ask you, those comments by the AG, were they comments as part of making his case in court?
Yes.
Yeah, so what's wrong with that?
Yes, but it is the reason why we filed first of all an application for review of the ruling the court made pursuant to that application and those statements from the Attorney General. And it's the reason why we have filed an appeal, and it is the reason why today we are moving an application for stay of proceedings in the High Court. So I'm showing you, the reason is that the comments he made in court were irresponsible, reckless, and prejudicial. Okay? And violates the ethics of the legal profession and the duties imposed on him as a Minister of Justice. And that is why we are not only raising those issues in the media, we have even raised it in courts. That it was irresponsible and prejudicial for the Attorney General to say that Honorable Gyakye Quayson is being irresponsible. In fact, at the time, so he said, was being irresponsible. Number one, that was an insulting comment. Then number two, you say that he's being irresponsible for putting himself up for election when he knows he can go to jail. But as a lawyer, as the leader of the bar, he ought to have known that even if you are prosecuting somebody, it doesn't stop the person from putting himself up for election.
Yeah, but
that is why Oshai Dampton, the MP for Tema East in 2020, whose case is on all fours with the Gyakye Quayson case. When he was standing for election in 2020 as member of parliament for the good people of Tema East, he was standing prosecution. Yet he contested, he won by over 4,000 votes. At the end of the day, the matter which was brought against him in court was dismissed. So it was very irresponsible.
My issue is that if the Attorney General were granting an interview outside of the court and he accepts those things, I could be on all fours with you. But if in prosecuting a matter in court, and I'm sure that this issue came about because the counsel for Gyakye Quayson had also made a case that, and this has to do with the issue of having a daily trial. and they had made a case that it was on a national assignment and he was contesting election, and therefore the daily trial thing was not appropriate or was going to, inhibit his thing. Obviously, the Attorney General, who has filed a case, and what he's praying the court to do is to find the person guilty and jail him for a criminal offense. Obviously, his response will be that, he knew what he was involved in, and yet he decided to go and contest the election.
No, you're not getting it. So,
the point I'm trying to make to you is that when lawyers, for example, file papers and they put things like frivolous and vexatious and all those things should not be considered insulting.
No, they should.
Why?
That is why in court, your words can be... If you file an application and the judge finds that anything in that document or any process you have filed before the court is prejudicial, to be struck out. It's unacceptable.
Yes, but I'm going to...
So
what I'm going to court.
I get you saying that because he didn't say that in the media, but he said that in court, it's okay. No. Because even in court, comments can be held to be prejudicial.
No, what I'm saying is that let the judge agree that those comments are prejudicial.
And I'm saying that...
You see, but both of you are in court.
No.
You are arguing your case.
No, I'm saying
and
that...
And then you come outside of the court. And you say that to the extent that he said this in arguing his case in court, he was being irresponsible.
Hold on.
Let the judge agree with you.
In courts, even during cross-examination, if you ask prejudicial comments, it will be disallowed.
Yes.
So I'm saying that the fact that he made that statement in court, it doesn't give him any immunity from criticism. Yes, the court is here to agree with us on that matter.
Yes.
The court did not even pronounce on whether or not the matter, the statement from the Attorney General was prejudicial. What the judge said was that relative to the application for review, it was irrelevant. And that is why we have gone a step higher to the Court of Appeal. You understand? But I'm saying that does not take away from us our rights, constitutional rights, to criticize the Attorney General, who number one is a public officer, who number one is supposed to be a Minister of Justice, for making prejudicial and irresponsible comments. You can't say that you have insulted my clients in court, and that because the judge is here to agree with me, I cannot criticize you for making an insulting comment. So what we are saying is that, yes, he made that statement in court, but in our opinion, such comments should not be coming from a Minister of Justice. Such because number one, the comment does not even make sense. What was the issue for determination in court? Whether or not Quayson's trial should be on a daily basis. Even murder suspects in this country, are they tried on a daily basis? Fraud suspects, are they tried on a daily basis? And so the lawyer for Quayson says that, look, Quayson has filed his nominations. Same has been accepted by the electoral management body, the EC. He is now a candidate in an election. And therefore, he's engaged in a public assignment, because a by-election is a public assignment. And then you have an Attorney General and Minister of Justice saying that, oh no, the by-election is a private matter. He is being irresponsible for putting himself up in such an election when he knows he is facing criminal prosecution that could land him in jail. Number one, the criminal prosecution can also lead to his discharge and acquittal.
Yes.
So why won't you present both sides?
But he's in court for a particular outcome.
The fact that you are in court for a particular outcome doesn't mean you can prejudge the matter. That is why lawyers are not even allowed to ask prejudicial questions. Once you have taken the matter to court, let the court determine whether the person is going to jail.
This is the same person who has come to the court and says that on the basis of ABCD, I believe that this guy is liable, or he has committed YXZ.
Yes.
So
it is only his belief.
So I want this outcome.
And the law says that even though you believe that, the person is presumed innocent until proven guilty, meaning his rights are intact.
Yes.
He has a right to contest as MP.
Yes.
Why will you make an argument that seeks to deprive him of that right?
But that's exactly what he has been doing from day one.
That is why it is wrong. No.
From day one.
If you just give me, let me just do.
No, you see, my point.
Seconds.
The point I'm trying to understand from you is that an Attorney General has gone to court.
Let me just give you one liner.
His case
to summarize what I'm saying on this point.
Yes.
It is irresponsible for an Attorney General and Minister of Justice to suggest that it is irresponsible for somebody facing criminal prosecution to contest a by-election. Because that is not the position of the law. The position of the law is that irrespective of whether or not you are standing criminal prosecution, you can contest a by-election. And he should uphold that law. That's my argument. Okay. Now, Doc, apart from the Attorney General, you have no less please, you speak that letter. You have no less a person than the President of the Republic himself, the appointer of Godfred Tame, the first gentleman of the land, who is a lawyer, making even more comments which are even more irresponsible, reprehensible, and reckless. He stands before Ahuna Bobrim, Nana Ajinsem, the paramount chief of Kushia, and other chiefs of Asenov, and he tells them that we are looking for somebody who can go to parliament to work, not somebody who is going to prison. Dr. Koboy, was that a responsible statement? Was that a responsible statement which should be coming from the first gentleman of the land, who is a lawyer? What that means is that the president has prejudged the matter. He knows. Obviously, because of what he's privy to and what he is doing behind the scenes, that Gyakye Quayson is going to prison. And that is why he can tell the people of Aseno that don't vote for somebody who is going to prison. Who told him Gyakye Quayson is going to prison? President Akufo-Addo is not going to prison. He, the one who has been caught on tape collecting bribe. He, the one who has people associated with him confessing to have given him bribe. He, the one who has supervised the most corrupt government in the history of this republic. He is not going to jail with his Galamsey appointees. But Gyakye Quayson, he can say that Gyakye Quayson is going to prison.
He is not on trial.
Okay. But there is no statute of limitation to crime.
Yeah, but he's not.
So he may not be on trial today. But that doesn't mean that he may not be on trial tomorrow. And his immunity is not absolute immunity. And the hole they have dug for Gyakye Quayson, like President Mahama told them at Aseno, they will rather fall into it. He and his appointees, his corrupt appointees, are the ones who will go to jail, not Gyakye Quayson, who has committed no crime, in our opinion. Then you have the Domahene's comment, an innocuous comment, an expression of his own opinion about the criminal trial currently pending before the High Court. The chief, who is also a High Court judge, having addressed himself with the circumstances of the case, makes a passionate appeal to the president. And Mr. President, if you have anything to do about this case, I'm appealing to you that you abort the trial. And before he made that appeal, he had canvassed his arguments, why he thinks that the matter, because of the peculiar circumstances of this case, the matter should be discontinued.